All right, it's 10 o'clock. Let's get started this morning. My name is Cindy Flynn, and I have Angela Serranzana from my office here as well.
Good morning, everyone.
And, over the last several weeks, Angela and I, along with all the employment attorneys in my office, have been flooded with calls and emails about the new laws, and we want to do everything we can to protect our business owners out there. So that is why we've put together this webinar for you guys in order to just stay protected. So I will share my screen. I hope everyone can see our presentation for this morning. In this week alone, 3 different new clients have walked through our doors. And all 3 of these clients have terminated somebody in the last 30 days. We are going to see an increase in employment law litigation over the next 6 months. And we want to do everything we can to help you prepare for this and protect yourself now before you make changes that we can't, change later on when an issue comes up. So that is why we are here today. Let's see here, some topics for today. We're going to go over the background of COVID-19, some new laws and orders, employee risk categories, employee leave, safety precautions, and travel. You will see on your screen a button for Q&A. If everyone can post their questions in that Q&A session, Angela and I will do our best to respond to everybody. This is a full house, so please bear with us as we navigate through all of the questions that have been coming in over the last couple weeks and the last several seminars we've done. So please use the Q&A rather than the chat box. Okay, since we are lawyers, we do want to share with you our disclaimer. Content on this webinar should not be considered legal advice, and it is for informational purposes only. Communications made through this webinar and/or participating in the webinar do not create an attorney-client relationship, and we are not responsible for any content that you may access from third-party resources that may be accessed through or linked to this webinar.
And Cindy, if I can just jump in here.
Of course.
So everyone, as you all know, this is a very, very quickly evolving situation with new laws being passed and interpretation of those laws kind of coming fast and furious. The advice that we're giving today is based on our understanding today. Of course, that may change as the situation develops, but of course, we will keep you all in the loop as we find out more information. There is, for example, right now, the House is currently voting on the CARES Act, which is the economic stimulus bill. It has not currently been passed or signed into law, but we do expect that later today. We'll be going over some of that at the very end of the seminar, but at the webinar. But of course, like I said, this is all very new, and we are trying to review this new information and interpret it as quickly as possible. So we do appreciate you bearing with us.
And please, if you have emails, bear with us. We've been getting a lot of emails over the last week or 2, and normally our response is to respond to everybody as quickly as possible, but due to the overwhelming number of emails we are getting, we are still doing our best to respond to everyone. So a little bit of background on COVID-19. The coronavirus is a virus that was first identified in China in late 2019, late last year. The term coronavirus refers to a type of virus which includes the common cold, SARS-CoV, and MERS. COVID-19 is a novel, new strain of coronavirus with a comparatively high transmissibility rate. So it spreads easily from person to person. The Center for Disease Control lists the reported symptoms as fever, cough, and shortness of breath. You can find out more information on cdc.gov, but these symptoms may appear 2 to 14 days after exposure. And currently, there is no vaccine to prevent COVID-19. So the California stay-home order, which which was signed March 19th, 2020, the whole purpose of the California stay-home order is to protect the public health of Californians by disrupting the viral spread. The supply chain, however, must continue, and there still will be access to food, prescriptions, and healthcare, and hopefully toilet paper. There is no expiration date as of right now, and this is enforceable under the government code section 8665. So the refusal or willful neglect to obey this order is punishable by a fine of up to $1,000 or imprisonment of up to 6 months. They are, they're not policing us, right, by walking down the street, making sure everyone stays inside, but it is enforceable if it comes to that. So stay at home or your place of residence and maintain your social distancing. If you must leave your home, leave for necessities only. So the federal government has identified 16 critical infrastructure sectors whose assets, systems, and networks, whether physical or virtual, are considered so vital to the country that their closure would have a debilitating effect on security, economic security, public health and safety, or any combination thereof. This means if you are not a critical sector, you and your employees must stay home. Angela and I do not have time to explain all the sectors in detail on this webinar, but if anyone has any questions on whether or not they fall under the critical infrastructure, we are happy to discuss that with you. You can also, go ahead, Angela.
Oh, sorry, I just wanted to also point out that these are the categories that are identified by the governor's executive order. There is also a Los Angeles County order that sets out its own essential businesses. I'm actually going to drop a link to the LA County order in the chat window here. You can go here because it actually has a broader range of categories that identify essential businesses. So if you're not included in the critical infrastructure categories listed here, go to the LA County health order to determine whether or not you may be covered there.
Perfect. And then the governor may designate additional sectors as critical as well. So this is changing a little bit, but thank you. So the Families First Coronavirus Response Act was signed into law March 18th, effective not later than 15 days after signature, which puts us at April, and it expires December 31st. This applies to all employers with less than 500 employees. There's no minimum. So if you have 499 employees or less, this applies to you. Now, I know we have a question about the exemption for businesses with fewer than 50 employees. This exemption is only if compliance of this would jeopardize the viability of the business.
Cindy, if you want me to sort of
please
expand upon that. So HR 6201 provides in the text of the bill that the DOL will issue, the Department of Labor will issue regulations setting forth the exemption and the procedures for getting the exemption. The DOL has not yet done that. That being said, 6201 does provide for that exemption, so it will happen. We just don't know what that is going to exactly look like because the DOL has not issued regulations. However, as Cindy says, it will apply to employers with less than 50 employees where the employer will potentially go out of business if they have to comply with these laws.
Right. And then HR 6201 modifies the Family Leave Act and creates an Emergency Paid Sick Leave Act, which we're going to go into detail in both of those. So under the FMLA modification, this is 12 weeks of job protected leave for your employees. This is available to employees who have been employed with you for 30 days or more. The first 10 days are unpaid, so employees can use accrued personal or sick days during this time, then employer paid leave. Leave can be used to self-quarantine, care for family members who are quarantined, or care for children due to school closures. We note that paid sick leave and kin care laws also may require employers to provide time off for parents dealing with school closures. The FMLA, after a 10-day waiting period, employers must compensate employees at least 2/3 of regular rate of pay, and in no event shall be paid leave exceed $200 cap per day and $10,000 in the aggregate. For the emergency paid sick leave.
Sorry, Cindy, while we're still on this.
Oh yeah, please.
There's a couple things that I want to just touch on here. First of all, this adds a category of protected leave under the FMLA. As far as we know, it does not add additional time to FMLA. So, for example, if you have an employee that has already used up their allotted FMLA leave for some other purpose, case law seems to indicate that this does not give them an additional amount of FMLA leave. It basically just adds a category. In terms of whether or not they have to have worked for 1,250 hours to qualify for FMLA. From what we can tell from the bill, it does seem to modify that provision, since it does say 30 days. An employee has to work for 30 days to be eligible for this. However, we have not seen any language that indicates that the other requirements for being eligible for FMLA leave apply. So for the time being, we will say that in an abundance of caution, you should provide it, but that's kind of still to be determined.
Right. And we are also happy to provide the slides from the presentation to anyone who emails, or I think I finally figured out a way after 6 presentations this week on how to automatically send them out. So if I'm able to do that, I will send them out after the presentation this morning. If I'm not able to do that, please email me. I'm happy to send them. Okay. So any other questions we need to address right now, Angela, under FMLA, the modification? I know we have a lot of questions coming in. Some of the stuff we will be covering later on.
Yeah, I think that you're about to go into answers to the questions that people are posing in the Q&A.
All right, wonderful. So under the Emergency Paid Sick Leave Act, it is for full-time employees, 80 hours of paid sick leave. For part-time employees, it's the average number of hours worked over a 2-week period. So this is paid at the employee's regular rate of pay. So this includes government quarantine or isolation order. We have been getting a lot of questions on whether or not the stay-at-home order is government quarantine or isolation. It is not. Quarantine is there's a legal definition to quarantine, and just because you are staying at home does not qualify. So the employees who fall under this would be doctor-advised self-quarantine and self-quarantine during COVID-19 symptoms. So the Emergency Paid Sick Leave Act can be used for the following and paid at 2/3 of the employee's regular rate of pay, no less than minimum wage, of course. And this includes caring for someone who is under quarantine or isolation order, caring for a child during a school or child care closure, or other substantially similar condition as specified by the Department of HHS. Again, remember that paid sick leave and kin care laws also may require employers to provide time off for parents dealing with school closures.
Cindy, if I can just jump in, somebody pointed out that it is I've seen guidance that indicates that it won't, that HR 6201 doesn't add additional leave. Somebody pointed out that they've read the law and they're not sure. And it may be best practices to allow the leave. If you want to act, I would say that I would agree with that. If you want to act in an abundance of caution, then provide additional leave over on top of the already provided FMLA, but our reading does not indicate that it would be additional time. Again, this is really quickly evolving. We're trying as fast as we can to read all the guidance possible. But agreed, if you want to, the way of addressing this with the most amount of caution would be to read these laws as broadly and generously as possible to avoid any litigation in the future.
Right. And then some advice we're getting about business owners should be encouraged to reach out and argue why not to shut down their business and not assume that they must. So that's from an audience member. Moving right along. There is no carryover from year to year under the Emergency Paid Sick Leave Act. So this is in addition to any leave program an employer may already have, and the employer cannot require that regular paid sick leave be used first. Okay, so for tax credits, the biggest question we are getting asked right now is, oh my gosh, how am I going to pay for this? Well, definitely speak to your CPA, because our understanding is that under both the Family and Medical Leave Act and the Emergency Paid Sick Leave Act, there is a credit for 100% of wages paid under the Act against quarterly payroll taxes. And this is under IRC Section 311A or 3221A. This credit cannot exceed the tax owed, but wages paid in excess of payroll taxes will be treated as a tax overpayment and refunded. So there's a credit of 100% of wages paid under FMLA and EPSL against the quarterly payroll taxes. It cannot exceed the tax owed. And employers' gross income will be increased by the amount of the credit to avoid a double benefit. So there's no windfall there. But stay tuned for guidance and regulations from the Department of Treasury, and then also check with your CPA for further information. You know, Angela and I have a very wide network of individuals that we trust and refer people to. So if you ever need a CPA referral or an insurance referral or a banker, you know, please reach out to us. We are always happy to make introductions. And that goes for other lawyers you may need too.
Just really quickly, Cindy, we got a question that says, describe what a quarantine isolation order would look like. And I know that we're going to go over this in the future in other slides coming up, but a quarantine or isolation order comes from a state, federal, or local authority that directs an individual to quarantine or self-isolate because of a specific reason, meaning travel to an area with a high level of viral activity, or COVID-19 consistent symptoms, or contact with someone with COVID-19 consistent symptoms, or contact with somebody who has come back from an area that has been identified from the state by the State Department. It does not apply to, in our reading, it does not apply to the current stay-at-home orders from the governor or the LA County, the LA City Mayor.
Yes, thank you. I'm going to talk about OSHA, the Occupational Safety and Health Administration, for businesses that have remained open as they are part of the critical sectors, or for when the stay-at-home order is lifted in California. OSHA has promulgated guidelines which identify employee risk categories to assist employers in determining what safety precautions are necessary for their workers. This is available at osha.gov. And there are 3 categories: high, medium, and low. Healthcare workers and healthcare support are considered high-risk categories. Employees with high-frequency contact with the general public, such as school staff, those working in high-volume retail, those working in high population density workplaces, constitute the medium exposure risk group. And then employees with minimum occupational contact with the general public and our coworkers, such as office employees or remote workers, they constitute the lower exposure risk. So employee categories to assess risks and determine next steps: those returning from affected areas, those in close contact with those who are returning from affected areas, those who have tested positive for COVID-19, and those who show signs and symptoms. We're going to talk about each one. So employees returning from affected areas, they will be required to self-quarantine for 14 days. We often get the question on whether or not the police are walking around making sure people are self-quarantined. The answer is no, it's just self-quarantine. They are hopefully doing that. But as an employer, you may require a medical release for them to return to work. And you may want to maintain a high level of alert for these specific employees who are returning from an affected area. They also may be required to undergo mandatory health screenings by federal, state, or local authorities. For employees who have come into close contact with individuals who are returning from affected areas, they may be required to self-quarantine. An employer may require a medical release for these employees to return to work as well. And you may want to maintain that high level of alert with regard to these employees. So employees who have tested positive for COVID-19, this is affecting more and more businesses. Immediately send those employees home, or that employee home, or have them remain at home. Immediately treat the affected areas in which the employee worked. We have a client doing this right now. There are specific recommendations on CDC on how to do this. And then you need to advise your employees and or customers who were in contact with that affected employee and offer reimbursement of medical testing for other employees. Do not identify the employee by name, but you also want to provide workers' compensation paperwork if applicable, and then also contact the CDC and local health department. For employees who are showing signs and symptoms, you may send an employee home upon observation of symptoms consistent with COVID-19. We have had clients ask us whether or not they can take the temperature of their employees to determine whether or not they have a fever. Angela, do you want to weigh in on this one?
So, yeah, the EEOC guidance has sort of blessed the use of, has blessed the taking of temperature. We are sort of reluctant to encourage anyone to do that, just because you open yourself up to all sorts of potential liability for, you know, why you ask somebody why you're taking somebody's temperature, and then also taking somebody's temperature does increase sort of interaction with the employee. We think it's best practices to send somebody to a medical professional to get clearance. We think that that's just, if you have a question as to whether or not somebody is exhibiting symptoms of that are consistent with COVID-19, first of all, document the symptoms in some sort. The manager or whoever is observing the symptoms and sends the employee to get tested or to get medical attention needs to document when it happens, document the symptoms that they observed, and then send the employee home. But we just really recommend leaving medical examinations and medical determinations to the medical professionals.
Absolutely, absolutely. For your employees who are showing signs or symptoms, though, you can require a medical release for them to return to work. Immediately treat the affected areas in which the employee worked per CDC, And then you may advise employees and or your customers who were in contact with the affected employee. Do not identify the employee by name. Emphasize that there's been no diagnosis yet, but you are just acting in an abundance of caution. So in order to assess risk, you may ask employees to inform you of the following. If they have come into contact with someone diagnosed with COVID-19, if they have a symptom of the virus or have been diagnosed with COVID-19, and you can also ask them to inform you of recent travel to exposed areas. You may not, however, target individual employees unless you have observed symptoms or have another objective basis for asking. You may not ask about any other underlying medical condition or medical disability or any information in that regard. So quarantine or sent home. So non-exempt employees sent home during a workday must be paid reporting time pay unless state of emergency includes a recommendation to cease operations. Exempt employees must be paid their full salary for any week in which they perform work. You can offer telework or remote work if it's administratively feasible in your business, but make sure that non-exempt employees have the ability to track time, as well as meal and rest breaks. This doesn't have to be fancy. You can have them sign a simple Excel spreadsheet with when they clocked in for the day, when they clocked in and out for their first rest period, their lunch period, and then their second rest break. And you can require leave of absence if telework is not feasible. I want to note here that reporting time pay does not apply when operations cannot commence or continue when recommended by civil authorities. This means that reporting time pay does apply under a state of emergency unless the state of emergency includes a recommendation to cease operations. So for, go ahead.
Sorry, really quickly, I just wanted to, there's a question in the chat that says, if you terminate or furlough an employee before they file for FMLA, then they cannot claim it, correct? Remind me, Cindy, are the furlough versus layoff coming up? Okay, so yeah. We are gonna address that shortly. And then, we're getting a lot of questions about documentation for all of this. We understand that medical professionals are stretched to their limits right now, and so somebody may not be able to get a written note from their doctor saying, you know, you have to self-isolate or you have to quarantine. At this point, best practices is to get some sort of written statement from the employee stating that this is what they're doing, and then request follow-up documentation as available.
Right. And then just a note on remote workers. There is case law that says if you have an employee using a cell phone for their job, it is mandatory to reimburse them for that expense, always. The employer would otherwise be receiving a windfall because it would be passing its operation expenses onto the employee. And the labor code says that the employer must pay some reasonable percentage of the employee's cell phone bill. We believe it doesn't even have to be a percentage, it can be a flat fee, but you also want to take that into consideration on paying for your employees' internet usage as well. You know, different cell phone plans and work-related scenarios and different internet packages that the employee has. It's the amount of the reimbursement is not clear. It just has to be reasonable. And just one more thing on that too, I should probably make a new slide for this. When you are having your employees work remotely, you know, you obviously want to keep track of breaks and lunches, which we just talked about, but you also want to have like an electronic use policy in place which says that if they step away from their laptop or their cell phone, that it goes dark after 30 seconds or a minute, and the employee has to re-enter the password just to keep any work documents safe. So it's one more step. I mean, I've heard people doing payroll at Starbucks and finding out that the $100,000 they were paying in payroll now got diverted into somebody else's account. So just clear policies like that to keep you protected. As employers, you can require employees to use accrued paid time off or vacation. As employers, you cannot require employees to use paid sick leave. So we're going to talk about reducing hours. Employees are eligible for partial or complete unemployment benefits if there is a reduction in hours, whether partial or total, whether permanent or temporary. So this means that your employees, if you cut them down in the amount of hours and pay subsequently, they are entitled to unemployment insurance. If business operations sees non-exempt employees are only entitled to hours actually worked and accrued unused vacation unless reporting time applies. Exempt employees are entitled to their full salary in any week in which they worked. If they do not work, then they can use the accrued unused vacation. So a little bit of differences between layoffs and furloughs. A layoff can be temporary or permanent. A furlough involves reducing the days or weeks that an employee may work. With layoffs, there are specific termination obligations. One is that you need to provide a notice to the employee as to the change in relationship. You need to provide Form 2320 for unemployment benefits information. You need to supply them with their final paycheck on the last day worked. This includes accrued vacation time and business expenses to date. One thing on the final paycheck as well, if you have your employees working from home and you lay them off, they need to get that final paycheck that day. And so it comes into issue, how do you get an employee their final paycheck on the last day that they're working if they are working remotely? And I would overnight a check to them and have them, ensure delivery that they get it that day. And if it's that one extra day, you're also paying them for that one extra day as well. So keep that in mind. You also need to provide COBRA notices and the health insurance premium notice. Be mindful that the Federal Worker Adjustment and Retraining Notification Act has notice requirements as well. And the WARN Act requires advance notice to covered employees, unions, and government officials prior to plant closing or mass layoff at a single site. Also wanted to touch on the WARN Act in California. Governor Newsom issued the executive order on Tuesday exempting businesses with more than 75 employees from part of the California Workers Adjustment and Retraining Notification Act, which requires giving workers 60 days notice before a mass layoff, relocation, or termination. The governor suspended that provision of the WARN Act effective March 4th, as long as businesses give employees as much notice as practicable and provide a brief statement of the basis for reducing the notification period. Governor Newsom said, because of the need to prevent or mitigate the spread of COVID-19, employers have had to close rapidly without providing their employees the advance notice required under California law. So the WARN Act requires employers with 75 or more employees to provide at least 60 days notice before a mass layoff, plant closure, or relocation. This is effective March 4th, 2020. Employers are exempt from the WARN Act 60-day notice requirement, and employers now must give as much notice as is practicable and provide a brief statement of the basis for reducing the notification period. Furloughs. Okay, So for non-exempt employees, you can schedule them for fewer days or fewer hours without liability concerns. You do not need to pay for the time worked unless reporting time pay applies. For exempt employees, this is really where it gets more complicated. Be mindful that when reducing an exempt employee's salary, it may bring them below the necessary salary for the exempt status, and they may be reclassified as non-exempt as a result. So where we are going to see employers get hit is when they take an employee who is currently exempt, meets all the qualifications to be exempt, but they cut their salary in half. And remember, for exempt employees, it's a two-part test. One is that they meet a certain salary threshold, and two, that the duties that you're having that employee do meets that criteria. So when you cut an employee from $90,000 a year down to $45,000 a year, you are going to make them non-exempt, which means you are going to have to keep track of their breaks, their lunches, their overtime pay, and all of the things that come with a non-exempt employee. So in order to protect yourselves, you want to reverse engineer essentially what that hourly rate would be and actually change it on their paychecks. It can't be just, oh, now you're making $45,000 a year salary. It has to be then converted into an hourly rate. And you want to be clear with overtime, breaks, and lunches just as you would for a non-exempt employee. And if you have an employee perform work in a work week, any work in a work week, they must be paid in full for that work week. And if no work is performed, then no salary is owed. But definitely provide advance notice to any reduction in schedule or pay. And then you also will want to check your benefits policy to determine if you can still provide benefits to furloughed employees. Angela, do you have anything to add on this right now?
Not really. It's just so important that you guys, before you make these salary reductions, do the calculations. In California, currently the salary threshold for employers with less than 26 employees is 49,000 and change. For employers with more than 26 employees, it's 54,000 and change. If you are going to be, and you can work out what the weekly rate is there. If you are going to be dropping their salary below those salary thresholds, you need to change them you need to convert them to hourly employees. I guarantee you that we are going to see a skyrocketing amount of wage and hour litigation with regard to this specific thing. So before you make any sort of reductions, make sure you do the calculations.
Right. Okay. One question we are getting frequently is whether an employee can refuse to come to work because of a fear of infection. And as this spreads, I mean, it's not an unreasonable fear, but unless the employee is being sent home, being sent to a high risk exposure area as identified by CDC or any other federal, state, or local agency, or if there's been some other consideration that creates an imminent or immediate threat of COVID-19 infection in the workplace, employees are not entitled to refuse to come to work. Can a larger employee terminate an employee who cannot come to work due to a school closure? Both the amended FMLA and EPSL would apply to the employee who needs to care for a child for COVID-19 related closures. In addition, once that leave expires or is used, the California Labor Code provides employees at work sites with 25 or more employees up to 40 hours of leave per year for specific school-related emergencies, such as the closure of a child's school or daycare by civil authorities. Employers may require employees to use their vacation time or paid time off benefits before they are allowed to take unpaid leave, but you cannot mandate that your employees use paid sick leave. However, a parent may choose to use any available paid sick leave to be with their child due to school closures, which would include EPSL. We expect guidance to be issued on the interplay between the amended FMLA and leave taken under this section. This means do not terminate under these circumstances unless you consult with your attorney. So California law requires employers to give notice of a change in relationship to any employee who is discharged, laid off, given a leave of absence, or whose status changes from employee to independent contractor, which, mind you, Angela and I do not recommend you move somebody who's an employee to independent contractor because of Dynamex 2 years ago, and then AB5, which came out, January 1st. If you have questions on independent contractors, reach out, but typically don't do it. No written notice is required if the employee quits, is promoted or demoted, if work stops due to a trade dispute, or if there's a change in work assignment or location. Although it's not required under California law, federal law provides that in some situations, including larger reductions in overall workforce, the employer must provide a written notice of the change. And California has explicit requirements for what information must be included in any notice of change in relationship. These requirements include 1, the name of the employer, 2, the name of the employee, 3, their social security number of the employee, 4, whether the action was a discharge, a layoff, a leave of absence, or a change in status from employee to independent contractor, and 5, the date of the action. Notably, there's no requirement that the notice specify whether a discharge was with or without cause. California law requires notice of change in the relationship to be given immediately, and that the notice be provided no later than the effective date of change in the employee's status. Although California law does not specify a particular service method for the notice, the safest practice is to physically provide a copy to the employee at the time of the employment action. If this is impractical, or if mail is the preferred service method, the notice should be sent to the employee no later than the effective date of the change in employment status. Failure to comply with California's notice requirement is a misdemeanor under the California Unemployment Insurance Code. And additionally, employees who are subject to a reduction in hours may qualify for unemployment insurance benefits. If everyone can just use the Q&A for questions, it's a lot easier for us to keep track of rather than through the chat box. So just as a reminder, if everyone can put questions in the chat box, it allows us to go through them a little bit easier. At this point, Angela, do we have any questions before we get into some safety precautions?
I mean, there are a million questions. So one, you just went over the requirements for discharge, layoff, or leave of absence. There is not a specific form that is required, but as Cindy went over, there are things for a change in status, the notice of change in status, but there are a number of things that you have to include, which Cindy just went over. Yes, is that right? Sorry.
Yeah. Mm-hmm.
Okay. Do we have to continue benefits if we have everyone on furlough? You should talk to your carrier about that. Technically, they are still employees on payroll. So you may be still on the hook for providing their benefits. You would not be responsible for covering their portion of benefits, but again, this is a question that you should talk to your carrier about.
What is the reasonable flat amount to reimburse for internet for a month? It just has to be reasonable. I mean, you can set it at $50. I think 35 would be reasonable. I think 100 would be reasonable. Angela, do you have any weigh-in on the exact amount to reimburse?
I don't.
Yeah, it's just whatever you think is reasonable. I know everyone's situation is a little bit different, but Hopefully that gives you some guidance. I would just say $50 is fine. Let's see. Yes, I can distribute the slides after the meeting. That is no problem. If I'm not able to figure out how to send them out automatically, please email me directly. Happy to give it to you. Angela, any other questions right now that we need to address before we have a lot of questions in here, guys. We're doing our best.
So here's a question. I will pose this question as so that I can get two at once. The questions relate to reduction of exempt employees, salaried employees. I just want to reiterate that you are allowed to drop an exempt employee's salary. You can reduce it down, but you just have to make sure that it doesn't fall below the thresholds established by California law, which again, in 2020 is 49,000 and change for employers with less than 26 employees. It's 54,000 and change for employers above 20 with over 26 employees. If you do drop, if their salary does drop below those thresholds, then you need to switch them to hourly employees. And absolutely, it can be on a temporary basis. That being said, you want to make sure that for the time period in which you are converting them from salaried employees to hourly employees, you, one, make sure that that's reflected on their pay stub along with an hourly rate. Two, you want to make sure that you are keeping track of their overtime hours, because once you've established that hourly rate, if they work overtime, then they are owed time and a half, 1.5 times their hourly rate if they work any overtime. So you want to keep track of that. Three, you want to make sure that you remember that as an hourly employee, they now are entitled to meal and rest breaks. So you want to keep track of that. But you can absolutely do it on a temporary basis.
Great. Thank you, Angela. Some safety precautions. Ensure that all frequently touched surfaces are cleaned and disinfected regularly throughout the day. This includes tables, doorknobs, light switches, countertops, handles, desks, phones, keyboards, toilets, faucets, and sinks. Err on the side of precaution when assessing risks. The CDC has provided a risk assessment guide on their website. You want to avoid conducting anything that could be considered a medical examination yourself. And this is what we were talking about earlier when, you know, we have clients asking whether or not they can take the temperature of their employees. Bottom line is we don't recommend it. If you are concerned about a particular employee displaying symptoms of COVID-19, send them home and advise them to see a doctor to receive medical clearance to return to work. If there is a question of whether or not COVID-19 was contracted in the course of the employee's work, provide that workers' compensation paperwork and leave it up to your carrier to determine whether or not they qualify for workers' comp. OSHA, the general duty clause requires employers to furnish to each worker employment and a place of employment which are free from hazards that are causing or likely to cause death or serious physical harm. Employees may refuse to come to work if they reasonably believe they are in imminent danger. And OSHA actually defines what imminent danger means. It includes any conditions or practices in any place of employment which are such that a danger exists which can reasonably be expected to cause death or serious physical harm immediately or before the imminence of such danger can be eliminated through the enforcement procedures otherwise provided for. Some travel guidelines. The World Health Organization has identified the current situation as a pandemic as of March 11th, 2020, and has issued travel guidance available on its website. The White House has issued multiple proclamations establishing restrictions on entry for certain individuals coming home from particular destinations. In addition, CDC has issued interim health guidance and advice for travelers, as well as a list of countries with restrictions on entry to the United States and a global map showing geographical risk assessment for COVID-19 transmission. The United States Department of State also maintains a searchable list with links of all of the destinations for which there are travel advisories currently in place. The Department of Homeland Security has directed that all individuals returning from restricted countries must travel through one of 13 airports and must self-quarantine for 14 days after their arrival. To the extent possible, eliminate or minimize business travel. To the extent possible, advise your employees that business travel is optional, and be aware of the destinations for which there are heightened levels of travel advisory. For personal travel, unless the employee traveled to a destination that has been identified by a federal or state agency as being of high risk than other destinations or of higher risk, absent symptoms, you should apply the same preventative measures as you would with any other employee. You can't prohibit them for personal travel, but you can ask about destination. So for some quick reminders, remember these considerations. Even though we are in a state of emergency, there are still state and federal privacy laws, including HIPAA, that may apply health records. And health records really need to be kept separate from personnel files. Employee health information should be kept confidential. I would recommend creating and enforcing clear policies and procedures for dealing with COVID-19 and apply them objectively. Angela, do we have any other questions? Maybe I'll just kind of continue. You know, no matter who you use as your employment attorney, make sure you're checking in with them frequently, at least twice a year, just because minimum wage goes up. Changes tend to come out January 1st and in LA, July 1st. Make sure that your employment attorneys are experienced. Angela has been with me for a couple of years. All the attorneys who work at our firm have 10 to 20 years of experience. You know, laws are changing, and we want to make sure that there are liability assessments done early on, including a review of all of the employment documents, so you as business owners know what's at stake. And at the end of the day, sometimes it comes down to a business decision. But assessing liability early on is definitely our recommendation. We have an employment compliance checklist I'm happy to share with anyone who's interested. It has a list of categories of things you can kind of check off to ensure you're compliant. And then you can text us to stay updated for our checklist and any other up-to-date news. Things are evolving very rapidly, and we are doing our best to pump out as much information as possible to all clients.
Really quickly, Cindy, since we do actually for once have a little bit of time at the end of this, I do want to touch base about the CARES Act, which is the Corona Aid, Relief, and Economic Security Act. It was passed by the Senate on late Wednesday night. It's currently pending before the House. The thought was that it would get passed today and sent to the White House for signature this afternoon. However, one representative has requested a voice vote, which may delay the passage of the bill, and we will be checking for updates as we go along. It is 800 pages, so I just want to focus on the highlights here. There's a lot of content involved, so I'm just going to touch on the most sought after information. One, the bill provides for $507 billion for individual payments to taxpayers. It's based on the 2019 tax return, although if you haven't filed it, it'll be based on the 2018 tax return. Each eligible taxpayer will receive a one-time payment of $1,200, $2,400 if married, filing jointly, plus $500 for each child under the age of 17. Those with incomes above $99,000 or $198,000 if filing jointly will not receive any payments.
And Angela, just one thing. It sounds like everyone is saying we've been tied up this morning on this webinar, but it sounds like everyone's saying that the House just passed the bill.
Okay,
So
well, so I just
thank you
want
all.
to, yeah, I literally checked right before, right
Yeah.
before we went on the webinar, and I have obviously been answering
Tied up.
questions, so not able to check my updates. I do see on my phone sitting right next to me that I have about 12 million Google alerts. So thank you all. But I will say this: I have
Yes.
not had a chance to compare. I'm assuming that based on the timing that the House bill is the bill that the House passed is substantially similar to the bill that the Senate passed. And so I'm just going to keep going over this really quickly.
Please, please.
There are expanded unemployment insurance benefits. The bill provides for an additional $250 billion in benefits. It increases benefit amount by $600 per week until July 31st. It increases the benefit period, and it loosens. And this is good to know. Loosens unemployment insurance eligibility to include those who are self-employed, gig workers, independent contractors, and freelancers. I'm sorry if I'm speaking really quickly. I just want to make sure that I touch on all of this before we end. This is the big one: small business loans. So these will be generally available for businesses with fewer than 500 employees. The bill provides for an additional $350 billion in loans under the Small Business Act during the covered period, which runs from February 15th to June 30th of this year. The funds are specifically available for payroll costs and are referred to as paycheck protection loans. You will not be able to double claim under the, you will not be able to double claim. If you get a loan, then you may not be able to claim the tax credit, but talk to your CPA about this. Payroll costs are defined as wages, commission, salary, or other similar compensation, as well as benefits. Payroll costs do not include the compensation of any individual employee in excess of an annual salary of $100,000. It does include payroll taxes. It does not include payroll taxes. Also does not include employees whose principal place of residence is outside the United States. And it does not cover any qualified leave or family medical leave for which a credit is allowed under 6201. Again, no double coverage. There are a lot of other things that go into this, but talk to your CPA about whether or not you are eligible for a small business loan under this provision. It should help offset some of the costs of this.
Great, thank you, Angela. Thank you. We have some more questions coming in. Let's see here.
So I am going to drop, we have questions about the EDD work sharing program. I'm actually going to drop a link to, so if everybody can look at the chat really quickly, I am going to drop a link to the EDD link, the webpage on the work sharing program.
Great. And then let's see here. Someone's asking to repeat the small business loan, what wages it covers and which ones it does not. Angela, I don't know if you want to repeat that information or.
Sure. Really quickly, payroll costs are defined as wages, commission, salary, or other compensation to an employee or independent contractor, payment of a cash tip or equivalent, payment for vacation, parental, medical sick leave, but not HR 6201 leave. Let's see, payment for group healthcare benefits, including premiums, payment of any retirement benefits, and payment of state or local tax assessed on the compensation of employee. This does not include other payroll taxes. Again, this is not, the tax part of it is not an area that I have expertise in, so definitely talk to your CPA about this.
Great. Great. Well, do we have time for one more question, Angela, that you want to address?
So this is a really good question. If a contractor applies for UI benefits, does this put the company they worked for at risk of an EDD or IRS audit for contractors? Yes. So they need to make sure, I mean, in California, absolutely. They need to make sure that they are identifying as a self-employed person if they are applying for UI benefits underneath the CARES Act. You need to talk to all of your contractors. First of all, if you guys have independent contractors,
Talk to us.
make sure that you talk to us or your employment lawyer to determine whether or not they should be. Second of all, if they are proper independent contractors, you need to call them and let them know that if they are going to apply for benefits under the CARES Act, they need to make sure that they identify as a self-employed person.
Absolutely. And
sorry.
yes, I can send the EDD link. And that's all we have time for. Thank you so much, everyone, for coming and joining us this morning. We hope everyone has a great weekend. And yeah, take care. Thank you.